No, I'm good. I think, Vishram, unless you want to hear some.
No, I think we can skip the facts.
Thank you.
Okay, thank you so much. If your lordship has no issues with the facts of the case, I shall proceed with my submissions. My lord, the appellant argues against the judgment of the court of first instance on two grounds. I will be dealing with the first ground, which is as follows. The judge erred in concluding that the DIFC has jurisdiction over the disputed trade due to the fact that Clevity has a node server within the DIFC, which satisfies Article 5A1B. The second ground will be dealt with my learned junior, Mrs. Janatul Fardos, which is as follows. The judge erred that for the purpose of Article 37, 1A of the DIFC contract law, the court did not need to examine the state of mind of the programmer when designing the program. If it pleases your lordship, I shall begin with my first submission. The appellant submits that the DIFC courts do not have jurisdiction over the disputed trade due to the unrecognition and prohibited crypto token YAPL. The DIFC has a regulatory framework for virtual assets under the jurisdiction of the Dubai Financial Service Authority, which I will later be referring to it as DEFSA. DEFSA rulebook states in A2 5.1 subsection A that a token is a crypto token if it is used or intended to be used as a medium of exchange or for investment purposes. Therefore, YAPL is in fact a crypto token because the parties have used it to buy and sell the crypto token. YAPL to gain profit, which is also an indication that the parties use YAPL as a form of investment. My lordship, I would like to bring to your attention the Protocol of Jurisdiction of 2004, section 3.3, which states that the DIFC courts shall have exclusive jurisdiction over disputes arising from transactions related to financial activities licensed to be performed within the DIFC. Under Article 41A3B of the regulatory law, a financial product is also prescribed to mean a crypto token, which means, your lordship, that YAPL crypto token must be a recognized and licensed cryptocurrency to perform financial activities within the DIFC in order for the DIFC to have jurisdiction over disputed transactions. The DEFSA rulebook under section 3A 1.1 subsection A that algorithmic tokens means a crypto token which uses or intends to use an algorithm to increase or decrease the supply of crypto tokens in order to stabilize its price or reduce volatility in its price. This is demonstrated by the fact that Beta is programmed to automatically offer YAPL for sale at a highly inflated price if there are no other users on the platform selling it. Therefore, this is made to preserve the value of YAPL, which will later increase the supply and demand for YAPL, as it would be scarce and it would be appealing to investors and stabilize its price. However, under the DEFSA rulebook 3A 2.3, DIFC are prohibited from conducting activities with algorithmic tokens. Consequently, YAPL is a prohibited crypto token under the DIFC because it involves the use of algorithms. The DEFSA guideline under 3A 2.1 states that it is prohibited to engage in activities with unrecognized crypto tokens, such as having exposure, using directives, or track an index that includes unrecognized crypto tokens, which means, your lordship, that the Clevity node servers based within the DIFC are prohibited from engaging and tracking transactions of YAPL because it is an unrecognized.
I'm sorry. Are you trying to say that, the appeal, where does this take you?
Your lordship, this takes me at the fact that the DIFC does not have jurisdiction to look over crypto tokens that use algorithms. So for instance, your lordship, the Dubai onshore would have a better jurisdiction to go over this dispute because the Dubai onshore recognizes algorithmic tokens as they can have jurisdiction over it. However, the DIFC, they are prohibited from having jurisdiction over algorithmic crypto tokens because they are unrecognized under the DIFC. Should
All right.
I?
Next, please. Proceed.
Thank you. So therefore, the Clevity node servers based within the DIFC are prohibited from engaging and tracking transactions of Apple because it's unrecognized crypto tokency under the DIFC. Thus, the disputed trade did not happen in part or wholly within the DIFC and does not satisfy Article 5A1B of the Jurisdictional Authority Law 2004. In conclusion, Your Honor, the judge erred in concluding that the DIFC courts has jurisdiction under Article 5A1B due to the fact that Clevity has a node server based within the DIFC. The judge should have held instead that the DIFC has jurisdiction over recognized and unprohibited crypto tokens under the conditions of DEFSA. Therefore, the disputed trade is outside the scope of the DIFC's jurisdiction. If I could be of further assistance to the court, this concludes the first ground for the appeal, for the appellant.
I think that's fine.
Yeah,
sorry.
no question from my side.
Your Lordship, I just want to clarify something before we move on. So I'm meaning to say that the crypto token YAPL uses algorithms, and algorithms are unrecognized under the DIFC. Therefore, they don't have jurisdiction to go over it. However, it does not mean that the DIFC does not have jurisdiction over other types of cryptocurrencies. So if I could just bring to your attention the decision number 23 of 2022 concerning crypto assets activity regulation, which regulates the crypto assets on onshore UAE. The crypto assets are defined as a record within an electronic network or distribution database, functioning as a medium for exchange from one holder to another through the operations of computer software or an algorithm governing its use. So the onshore recognizes algorithmic tokens. That's why they will have a stronger jurisdiction to go over the disputed trade, which has algorithmic token. Does that clarify my position?
Yes, clear for me. Thank you.
Thank you.
Yes.
Please proceed, counsel. Hi, can the appellant please proceed to the next submission?
Your Lordship, do you mean the junior counsel for the appellant?
Yes.
No, the
please.
respondent. No, Vishwan, under the rules, the respondent.
No. Yeah, sorry.
The respondent, senior counsel.
Hello, can you hear me?
Yes, we can hear you.
Okay, should I start?
Yes, please.
Okay. May it please the court, as introduced by my learned friend, my name is Jeffrey Aftab, and I'm the senior counsel for respondent Ms. Rosrani. I will be assisted by my learned junior, Mr. Muhammad Toyo. I will be addressing your lordship on the first ground of appeal, namely that the first instance court of error in concluding that because Clevity operated a distributed ledger with a node in the DIFC court had jurisdiction over the claim by Ms. Rosrani against Mr. Payne under Article 5A1B of the Judicial Authority Law. My learned junior will be addressing your lordship on the second ground of appeal, which say that the first instance court error in concluding that for the purpose of a claim to avoid the disputed trade, it was sufficient for the purpose of satisfying Article 37(1)A of the DIFC contract law that Ms. Rajrani shows that a reasonable trader with knowledge of circumstances surrounding the transaction would have concluded that dispute trade was the result of an error. My lord, I have two submissions to make. Firstly, since Clevity operates a distributed ledger with one of its notes in the DIFC, it can be concluded that the transaction has been wholly or partly performed within DIFC. Thus, DIFC courts have jurisdiction in this case. Second, since the parties had not chosen the legal jurisdictions before entering into the contract, thus by default, the DIFC laws would be applicable on both parties. Moreover, DIFC courts can exercise enforcement regionally through the GCC Convention, which applies to Oman as well. If it pleases your lordship, I shall now begin with my first submission. The respondent submits that the judge of the first court of instance did not err in concluding that the GIFC court had jurisdiction in this case, as Clevity operated a distributed ledger with one of its notes in the DIFC. The judicial authority law states that the court of first instance shall have exclusive jurisdiction to hear and determine any civil or commercial claims and actions arising out of or relating to any incident or transaction which has been wholly or partly performed within DIFC and is related to DIFC activities. Since Clevity operates a distributed ledger with one of its notes in the DIFC, it can be concluded that the transaction has been wholly or partly performed within DIFC. Moreover, virtual assets like cryptocurrency are categorized as one of DIFC's activities. As the DIFC, a prominent free zone within the UAE, has its own regulatory framework for virtual assets under the jurisdiction of the Dubai Financial Services Authority. My lord, I would like to bring to your notice the case of the Lotus case reported in the year 1926. In 1926, a French steamboat, the SS Lotus, collided with a Turkish steamboat, the boat's court. This resulted in the sinking of the Turkish boat and the death of 8 Turkish nationals. Turkish authorities instituted criminal proceedings against a French officer on duty aboard the SS. This case established that a state will have jurisdiction over incidents that were completed in its territory, even though some element constituting the civil wrong or the offense took place abroad. Thus, it can be implied that since Clevity operates a distributed ledger with one of its notes in the DIFC, it can be concluded that the transaction and this incident of disputed trade has been wholly or partly performed within the DIFC, and thus the DIFC courts have jurisdiction in this case. My lord, I will now be moving to my second submission. The official DIFC court website states that the DIFC laws allow for any institution operating within the DIFC to select a legal jurisdiction of its choice other than the DIFC when entering into contracts. However, in the event that parties do not do so, the DIFC laws will be applicable by default and they can file a case in the DIFC courts. Since Clevity operated a distributed ledger with one of its notes in the DIFC, and since the party had not chosen the legal jurisdictions before entering into the contract, thus by default the DIFC laws would be applicable on both parties. Through the UK-Netherlands Agreement 1999, it was established that a state may agree by treaty that another state can exercise enforcement jurisdiction within its territory for a specific purpose. Judgments of the DIFC courts can be enforced locally, regionally, and internationally through treaties such as the GCC Convention, which apply to both Oman and UAE as well. Article 4D of the GCC Convention states that in the event of non-contractual liability, if the act, the subject matter of the liability occurred in the territory of such state, then the court of the state in which a judgment is issued shall be considered to have jurisdiction. Thus, DIFC courts have jurisdiction as one of the notes of Clevity is located in DIFC. Hence, it can be implied that the transaction took place at DIFC. In addition to that, my lord, I would like to bring to your notice the case of Conrad Pipeworks, SA, and Barclays Bank, reported in the year 2011. For the benefits of your lordship, the facts of the case are as follows. The appellant claimed damages against the respondent for a tort committed outside the DIFC, but sued the respondent in the DIFC court invoking Article 5A1A of Dubai Law number 12 of 2004 on the grounds that the respondent, as well as a registered company in the DIFC, was accordingly a center establishment under Article 5A1A. The court held that the DIFC courts did not have jurisdiction to hear a claim against Barclays Bank, even though one of the branches of Barclays Bank was located at the DIFC, because the dispute involved the activities of Barclays Bank located in Jebel Ali, which was not related to the activities of the DIFC branch of Barclays Bank. This case can be distinguished from our case as all the notes of clarity complete transactions, thus performing the same function. Hence, DIFC laws are applicable in this case because clarity does not have different branches or nodes performing different functions. Mr. Payne has indirectly accepted that the DIFC codes laws are applicable to this case by appealing against the judgment of the Digital Economic Court, which is the division of First Court of Instance. Moreover, cryptocurrency is not regulated by any of the laws in Oman. Hence, Oman courts cannot apply any laws or regulations to protect the consumers from the risk of trading virtual assets. Thus, the appellant, Mr. Payne, who currently resides in Oman, cannot argue that Oman courts have jurisdiction over this case. It is the submission of the respondent that the Court of Appeal follows the decision made by the Court of First Instance. The DIFC court should have jurisdiction over the claim and dismiss the appeal. My Lord, I will now be moving to my conclusion. In conclusion, it is the submission of the respondent that the judge of the First Court of Instance did not err in concluding that the DIFC courts had jurisdiction. My learned junior, Mr. Muhammad Tayyib, will now address your lordship to the second ground of appeal. I would like to invite your lordship to hold a decision made and dismiss this appeal. With that, your lordship, this concludes my submission for the respondent.
Thank you, counsel.
Thank you.
No questions from my side. I don't know, Rishabh.
Not from me either.
No, okay.
Appellant, do you have a rebuttal?
Excuse me, hi. So I'm the junior appellant, and for some reason the senior appellant is
We
not being
need to
able.
hear the senior appellant's rebuttal. Is there one?
Sorry?
Is there a rebuttal by the senior appellant?
Your lordship,
No,
I was
we wanted
facing
to.
some,
Can you not
Okay,
oversee?
you're back.
your lordship, I was facing some technical difficulties and I could not hear what the respondent was saying. So
Brilliant. Okay, let's proceed. Appellant, do you want to open the junior appellant?
Yes, I'll do it right now. Let me just switch on my video. Am I audible?
Yes.
Okay, perfect. Okay, so may it please your lordship, my name is Jonathan Firdos, and I appear as the junior counsel representing the appellant, Mr. Laith Payne, alongside my learned co-counsel, Ms. Nada Yahya, who appeared as senior counsel for the appellant. Your lordship, I'll be dealing with the second ground, which deals with the question under Section 37, Article 37, Section 1, Subsection A of the DIFC contract law. Would a reasonable trader with the knowledge of the circumstances surrounding the transaction conclude that the disputed trade was the result of an error? In relation to the second ground, your lordship, I have 3 submissions to make. If it pleases your lordship, I'll begin with my first submission, which is that your lordship, Mr. Payne did not commit a mistake. He programmed beta in such a manner that if there were no other users offering to sell YAPL on the Clevity platform, YAPL would be offered for a highly inflated price. This is a rather known tactic that is used in the commercial world. At the same time of the glitch, there were no other users offering to sell Yapple other than Mr. Payne, making him the only person offering to sell the Yapple crypto token in the entire platform. The program had acted in the way Mr. Payne had intended, which is to increase the value of the crypto token at times of the token being rare or not easy to obtain. There is no mistake in the way the transaction was carried out. Further, Your Lordship established uh, in the DIFC contract law, DIFC law number 6 of 2004, Article 37, Section 2, subsection B, it is stated that a party may not avoid the contract if the mistake relates to a matter in regard to which the risk of mistake was assumed. Which brings me, Your Lordship, to my second ground. As Ms. Razi had created the alpha program herself, she should be aware that it is inherently risky for her to code the software to complete automatic transactions without human approval or consent before each trade. It is plausible to assume that the electronic programs at times do not run as planned. The program Ms. Razi created, Alpha, was designed to make completely legal transactions on her behalf. The glitch that occurred does not make the transaction invalid, as both the programs ran as coded by the parties. To refer to a case in Smith versus Zimbalist, I hope I'm saying it right, 1935, it was established that parties dealing with inherently risky business practice, such as buying and selling of antique guitars, should assume that the uncertainty that come with such practices in the sense is common, and that Ms. Razi should have assumed the risk that comes behind coding a program that automatically completes transactions on her behalf. Lastly, my lordship, I will now move on to my third submission. According to the UniDroit Principles of International Commercial Contracts 2004, under Article 3, Section 4, the definition of a mistake is considered as an erroneous assumption relating to facts or to law existing when the contract was concluded. So that means that at the time the trade took place, Mr. Payne's Yapple token was factually the best possible price available on the Clevity platform. Therefore, it should not be categorized as a mistake as it does not fit the definition under Article 3, Section 4. And as established above, Your Lordship, the program had run as coded by both parties exactly the way which had been planned. Further, Your Lordship, according to Article 37, Section 1, subsection A of the DIFC contract law, DIFC law number 6 of 2004, which was mentioned earlier, it is provided that a party may only avoid a contract for mistake if the mistake was of such importance that a reasonable person in the same situation as the party would not have concluded it at all if the true state of affairs had been known at the time of the contract. In the instant case, there existed no possibility for Mr. Payne to predict the glitch in the program, as the glitch caused were for completely independent reasons that Mr. Payne had no control over. In Mr. Payne's situation, all that had occurred was the lawfully executed transaction as per the way both beta and alpha had been coded. This concludes my submissions, Your Lordship. It is for these reasons and also those that have been given by my co-counsel, Ms. Nada, that I urge you to allow the appeal I urge you to allow the appeal unless I can be of further assistance. And that is all. Thank you so much.
Thank you. Respondent?
Good morning, everyone. May it please the court, my name is Mohammed Twaib and I'm the junior counsel for the respondents. Ms. Rajrani. I will be addressing Your Honor on the second ground of appeal, which is as follows. The first instance court made an error in concluding that for the purpose of a claim to avoid the disputed trade, it was sufficient for the purpose of satisfying Article 37, Section 1, subsection A of the DIFC contract law that Ms. Razi showed that a reasonable trader with the knowledge of the circumstances surrounding the transaction would have concluded that disputed trade was the result of an error. Your Honor, this concludes my first ground of appeal. I have two submissions to make for the second ground of appeal, which are, my first submission is, disputed trade has occurred due to a mistake. The second submission is that any reasonable person with knowledge of this transaction would have concluded that the transaction occurred due to a mistake. For the benefit of Your Honor, I will begin with my first submission. According to Article 37, subsection 1 of DIFC contract law states that a party may only avoid a contract for mistake if, when the contract was concluded, the mistake was of such importance that a reasonable person in the same situation as the party would have not concluded if the true state of affairs would have been known. And if you look at subsection A, it states that section 2, sorry. However, a party may not avoid the contract if subsection B states that the mistake relates to a matter in regard to which the risk of the mistake was assumed. In this case, my client, Mr. Leith Payne, yes, he had assumed the mistake because he was dealing in cryptocurrency, which is a volatile product. However, the price of the cryptocurrency had highly increased, which was unforeseeable by my client. Although the risk was assumed, but the extent and the extremeness of the risk was not assumed by my client, because for the price of the cryptocurrency to be increased by 250 times was unforeseeable by my client. So in the case of Bell and Lever Bros Limited, 1931, which is a UK case, in this case it was held that in order for the contract to be void for mistake, the mistake must involve the actual subject matter of the agreement and must be of such a fundamental character so as to constitute an underlying assumption without which the parties would not have entered into the agreements. By applying this case to our present case, it can be confirmed that the price of the cryptocurrency was the most fundamental part of the contract, and my client would not have got into the contract if she had known the true circumstances and the price of 100 Apple coins has increased by 250 times. Although the risk of trading in cryptocurrency was assumed by my client, the cryptocurrency is a volatile product and the prices fluctuate frequently. But for the price to increase by 250 times within less than a day was completely unforeseeable. And this was an extreme fluctuation which never happened in the history of cryptocurrency. In common law, the general rule is the mistake which occurred must be very significant and important, and the parties would not have entered into a contract if they were aware of the mistake. Similarly, if my client, Ms. Rajrani, knew about the mistake, she would not have entered into the contract, since the price of the cryptocurrency was the most crucial part of the contract. I would move on to my second case, which is Hartog and Collin and Shields. This is also a case of the UK. So in this case, Collin and Shields were selling Argentinian rabbits skins to Mr. Hartog. However, Collin and Shields mistakenly wrote a price per pound per kg. So in the contract, they were selling the Argentinian hare skins per kg instead of selling it per skin or per piece. Because of this mistake, the price was reduced to 1/3 of the price previously discussed and orally agreed upon. So instead of the price being £100,000, the price was reduced to £30,000, and there was a significant loss faced by Collins and Shields. In this case, the court held that the contract was void for mistake, as hareskins were generally sold per piece, and given the price, the claimant must have realized the mistake. Consequently, the judge held in favor of Collins and Shields on the grounds that the plaintiff must have realized the defendant's error, as this was concerned and this was related as this was one of the most fundamental term of the contract, and thus the contract was rendered void. So what I'm trying to imply here is that if Miss Razi knew that 100 coins of Yapple would cost her $250,000, she would not have entered into a contract with Mr. Payne, as this is a very highly inflated price. Moreover, the prevailing market price was $10 for one Yapple, a cryptocurrency coin. So 100 Yapple so 100 Yapple coins would have originally or previously they would have been $1,000, but as of now and due to a disputed trade which occurred, the price has increased to $250,000 instead of $1,000. So there is a extreme price increase by 250 times. Hence, it was reasonable to conclude that the disputed trade was a result of an error. I would like to move on to my next case, which is a DIFC case. So in the case of Gila LLC and Gilad LLC, this was the 84th case in 2016 in the Small Claims Tribunal case courts. So I would like to give brief facts of the case. So in this case, the claimant is the landowner and he is renting out a commercial unit to the defendant, who is about to open a beauty salon shop in DIFC. The defendant's representatives went to inspect and examine the location and the size, the size of the unit. Excuse me. And when the claimant requested for the outline and architectural design of the unit, one of the former employees of the claimant made a mistake and sent the wrong location and size of the unit to the defendant, and the contract was signed. When the defendant realized that the unit shown to him earlier and the design of the unit sent by the claimant are two different units and in different sizes, he expressed his concern to the claimant, but the claimant did not make any changes. But since the defendant did not get his desired unit at the desired location, he was not able to make enough profits to pay his rent to the landowner, who was the claimant. Thus, the claimant sued the defendant for breach of contract because the defendant failed to fulfill his obligation, which was to pay 220,000 dirhams annually as a rent. And he also sued for, and he additionally sued for the bounce check, and the total claim was for 300,000 by the claimant, whereas the defendant was seeking 380,000 dirhams from the claimant for reimbursement of the lost income during the elongated fit-out period, and because of the salaries, and because the defendant was given the wrong unit and in the wrong location, he was not able to generate enough profit, and because of which he was not able to pay the rent, and he was also not able to pay the salaries to his employees for 3 months. And he wanted the lease agreement to be extended and decrease in the rent since the new unit is of a smaller size. The DIFC courts held that under the DIFC contract law, the defendant can only escape its obligations under the lease agreement if it can demonstrate that when the contract was concluded, the mistake regarding the location and size of the premises was of such importance that a reasonable person in the same situation as the defendant would not have concluded it at all if the true state of affairs had been known. And the judge stated that, and I quote, "I am of the view that a reasonable person would take the view that a mistake regarding the location and size of the retail unit in the lease agreement is of such importance that he or she would not have concluded it if the true state of affairs had been known. In addition, the claimant had caused the mistake by identifying the wrong unit in correspondence with the defendant. Thus, the DIFC courts additionally stated that the defendant can hold the contract void as there was a unilateral mistake as to the size and location of the unit, which was the essence of the contract. However, since there is no application by the defendant to void the lease agreement under the DIFC contract law, thus the lease agreement remains in effect and the defendant shall be provided with remedies and he shall be compensated. Thus the judge concluded that where the mistake is crucial to the fundamental terms of the contract, a reasonable person in the same situation as the defendant would not have concluded it at all if the true state of affairs had been known. So in our present case, Mr. Payne, when Mr. Payne had sold the 100 Apple coins to Ms. Razrani for $250,000, Ms. Razrani would have never got into the contract if she had known that the coins were being sold for $250,000. Hence, it can be concluded that the whole transaction and the disputed trade occurred due to a mistake. And we urge that the court holds the contract to be void for the mistake. With that, Your Honor, this concludes my second submission for the respondents. I would like to invite Your Lordship to reject the appeal, and with that, Your Honor, this concludes my submissions for the respondents.
All right, I think that's it from us. Vishram, do you have any questions?
No, nothing from my side. Thank you.
Perfect. Thank you, teams. I think we'll email the organizers the scores, and good luck for the next rounds.
Thank you, everybody.